And now I'd like to introduce founder and CEO of SafeScreen, William Cage.
Thank you. Good morning. All right, chamber members. So it's kind of a dry subject, but we'll keep it just sort of cursory, sort of an overview. This is in no means an expert level course on this topic, but just to give you an idea of what are backgrounds, how do I do this, should I do it, why, that type of thing. I'll skip a CV or resume or bio, other than about 36 years of law enforcement, criminal investigator, licensed private investigator, in-house corporate, or U.S. government contract investigator. So that's kind of my background. I've been running SafeScreen for about 10 years, providing mostly employment related, but also professional associations, volunteers, students, and others. In other words, legally compliant backgrounds as opposed to the online site where you punch in your credit card information, put in your subject's name, and poof, you have a record. I won't be talking about those in this, and if you see that type of service and you're using it for employment purposes, big red flag, don't use them. They're illegal for you to use and basically worthless. So, moving along here, I do have to mention to you that I'm not a lawyer. So, nothing is intended to be legal advice. I won't be giving legal advice. Instead, I'll be giving you business information based on my education, background, experience, and training. So, again, any questions on the legalese, go ahead and talk to a qualified counsel who understands backgrounds and all the laws related to it. So let's just jump into a couple of terms here. There is no real standardized definition of these terms that you see in front of you, which is background check, background or pre-employment screening, or background investigation. Background checks or screening is a term that came up within the industry generally to prove or disprove facts, things which are known. So it's kind of at the lower end of things. The applicant provides information, and a screening or background check sort of does some basic checking to see if that's accurate. Is that really that person? Do they or do they not have a criminal record? Do they or do they not have a valid driver's license? That type of stuff. Background investigation, because of the term investigation, is more of a let's delve into this person's background and find out more about them. Maybe things they didn't tell us. So that's sort of the basics of the terminology. So step one, if you are a business owner or a manager or in an HR position or any other position that would involve checking the backgrounds of mostly employees, question one might be, why should you conduct background checks? So within civil law, tort law, there are some known concepts referred to as negligent hiring, negligent retention. There's aspects of workplace violence, and then a term called the insider threat. So what are the basics of these things? Oh, also, let's talk about embezzlement and fraud, avoiding time of cost of a bad hire. And then some positions are regulated. You're kind of required to do this. So if you're the employer and you hire an employee and you don't check their background and they do something wrong, and it turns out they have some sort of provable record of doing something similarly wrong, you might be faced with that negligent hiring and or negligent retention civil suit. The concept being you should have known, or you did know and you still hired them, one of the two. Embezzlement and fraud is huge. Embezzlement is the stealing, but stealing from an employer. So that's employees stealing your money, or also stealing the money from your clients. Time and cost of a bad hire. The Society for Human Resource Management has done some studies that indicate up to 5 times the employee's salary is what your cost is when you have a bad hire, for whatever the reason might be. So doing this screening beforehand, you end up not hiring some people that aren't going to work out. Then you avoid that cost of recruiting and onboarding and training and so forth, the replacement for the person you just got rid of. Regulated positions, there are some positions such as, we'll say, school teachers. You are required by law to perform a certain type of background check. So you have no option. Whatever it says you have to do, that's what you have to do, because that's the law. So we talked about wrongful acts, civil matters, torts, that's all related. That's all under civil law where you as the employer might do something wrong and end up getting sued for it. So this particular one that we're talking about here, negligent hiring imposes a general duty of the employer to conduct a reasonable background check on a potential employee to ensure that the employee is fit for the position. That's actually a Nevada case. So this is case law, where a case has already been determined by a court. This is what they've ruled, and if you're involved in a similar circumstance, attorneys are going to do the research, bring this up, and present this as case law, meaning this is established law, you should follow it. Another active aspect of case law here. The employer breaches this duty when it hires an employee, even though the employer knew or should have known by that employee's dangerous propensities. So in this particular case, what they're talking about is you as the employer either knew about their background and you chose to hire them anyway, or you should have known. So you can't say, well, I didn't do a background, I didn't know, so I'm absolved of all wrongdoing here. Doesn't work that way. So remember that key phrase, knew or should have known, because you hear that a lot. So plenty of reasons why you should consider doing background checks. Well, what do you do now? How do you conduct a background check? So we have some options here. We'll talk about the FBI/fingerprint background, doing a background in-house, outsourcing it to a vendor, or a hybrid model. So the FBI background check. First, just a quick dispelling of myths. A lot of people talk about how they had a background check by the FBI when they had no such thing. So if you're a teacher, you're in banking, that type of thing, and you've had a quote-unquote FBI background check, probably what you did is you went down and you submitted your fingerprints. Nowadays, it's all done digitally. Your fingers are rolled across a glass plate on a scanner, and it gets submitted to the state repository here, in our case, Carson City, and to the FBI in West Virginia. They match those prints, look for a record, and report back certain aspects of those records. So that's really a fingerprint-based criminal record search. That's all it is. The FBI did not go out and knock on the doors of your neighbors and talk to your coworkers and your supervisors and look at a bunch of records. They didn't do any of that stuff. However, a lot of legislation likes the FBI fingerprint check. There are reasons why it's not quite what it stacked up to be, but basically, if it's in the law, as I said before, it's in the law. You don't have a choice. Also, if you're not in a regulated industry, let's say you own an office supply store and you want to do an FBI fingerprint check on your employees, you can't do it. The only time you can do it is if it's in the law, if it's regulated. So you don't have the option. So figure out if you're in a regulated industry, figure out what you need to do, and kind of go from there. As I said, it's only a criminal record check. There is no one source for all criminal records in America. If you watch TV, any police officer gets to a computer terminal, types your name in, and poof, every record you've ever had anywhere shows up. And that's Hollywood's version, but the reality is it doesn't work that way. There are a lot of reasons why records don't make it to the FBI, but of those that they have, government audits have shown half of them are not up to date, which most people don't realize, and it's kind of shocking. And again, as I said, it's only allowed by law. So if it's a regulated industry, you have to do it. If it's not, you can't do it. So what's another option? So an in-house background check, and by that I mean you, the employer, or your staff, conduct a background investigation or background check using your own staff and your own resources. So some of the pros of this is you have the most control over the reduction of the time. If you want it faster, well, just do it faster. Or direct your employee to do it faster. It may or may not be more or less cost effective. There are a variety of factors to consider. Generally, it's not covered by the Fair Credit Reporting Act, and that's a separate act we'll talk about a little bit further down the line. But it's basically the main federal law that regulates how these background checks are done for employment purposes. And I'll explain why it may or may not be covered by that. So outsourced background checks, that's another option. That's where you hire a vendor. I'm a vendor. I provide background checks for my clients. So they come to me, and I take care of everything else. The legalese, the paperwork, the documentation, collecting the information, conducting a background, generating a report. So that's why it's generally the simplest option. My clients initiate a background check 90-some% of the time with simply entering their applicant's name and email address, and then they're done. So obviously that's pretty easy as opposed to you actually doing the work. Vendors also provide the forms and notices that remain up to date on ever-changing federal, state, and local laws, which is constant. Provides a process, and these days is generally online and a secure website. It's expedient. We also provide the customer service to both you and also your applicant if a question comes up or there's some sort of a problem during the process. So that'd be outsourced. And then hybrid of in-house and outsourced. So maybe you take certain individual tasks that you want to do. Maybe you want to call references and have a chat with the reference yourself. Maybe you get a better feel for the background of that employee by doing that yourself, but you don't want to deal with driving records and criminal records or civil records or educational verification or whatever the other aspects that's being done. So you do some stuff, and you have a vendor do some stuff. So that would be a hybrid model. So you're going to do backgrounds. You made that decision. Now what do you do? So I mentioned that Fair Credit Reporting Act, or FCRA. It'll come up a lot. It's very confusing. Even to those of us in the industry, it's very confusing. By the name, credit. So everyone sees this, generally people think, oh, credit reporting. So if I run my TransUnion or Equifax credit report, this law relates to that. And that's true. But also, very ambiguous language, which has been interpreted by the federal government to include the report that I, as a background screening company, generate to you, the employer, is considered a consumer report. So it falls under this law. And there's a bunch of stuff that both you and me as the vendor have to follow. Otherwise, you're violating federal law. There are criminal penalties in some cases and civil penalties in others based on what you did. So, as a background check vendor, I'm considered a consumer reporting agency. And there's a bunch of legalese as to, why that is. But when you start talking about other information on consumers, that's part of what brings this law into it. Also, when you start talking about character, general reputation, personal characteristics of the quote-unquote consumer, and remember the consumer is also in this case a job applicant, and related to employment purposes. That's what makes it part of the FCRA or that federal law. Also, employment purposes doesn't just mean hiring somebody. It means hiring someone, firing somebody, promoting somebody, transferring them, anything related to their employment if you run a background. Some places you've been hired, you're about to be promoted, you get a different level of background check even though you're still an employee. That's for employment purposes, or some kind of promotion or transfer or change of job duties, that type of thing. So a failure to comply with the FCRA requirements exposes the CRA, that's me, the vendor that's doing the background checks, as well as the CRA's customer, that's you, the employer, to both civil and criminal penalties. That's bad. We don't want that. We want to avoid that. So does the Fair Credit Reporting Act apply? So if everything you do to check the background on your potential employee is done in-house, meaning you, your people, your resources, nothing outside of that, the FCRA does not apply. You can skip a bunch of stuff. If you use a third-party consumer reporting agency, someone like MyService, the FCRA applies. Or if you use that hybrid model of you do some stuff and an outside vendor does some stuff, then the law applies. So just understand that. If the FCRA applies, one of the various aspects of that means limitations on reporting. So I do a background, and I uncover information, and I generate a report to my client, the employer, and it may not have everything that I could possibly find on there. The following items cannot be reported: civil suits, civil judgments, records of arrest that do not include a conviction that are more than 7 years old. Bankruptcies more than 10, tax liens 7 years, accounts placed for collection, other adverse information 7 years. So the way they look at it is a conviction is different than an arrest, and it is. The level of the requirement there between a police officer having a reasonable suspicion and beyond a reasonable doubt for a conviction are completely different. So they say, just like if you have an old unpaid account in your credit bureau report, it has to drop off after 7 years. An arrest would have to drop off after 7 years. A conviction can be reported forever. Well, at least in Nevada and for now. But it doesn't apply to every state and every city, and it's constantly changing. So, steps to be compliant with the federal law as an employer. Several requirements are clear and conspicuous written disclosure, a written authorization from the consumer to conduct the background, something called a summary of your rights, a couple of page document put out by the Federal Trade Commission, giving them their rights as a consumer. If a CRA, if an outside vendor, someone like my firm, generates a report to you, the employer, and you find something in there that causes you to not hire someone or not promote somebody or terminate them, whatever, any employment purpose, there's a two-step process you're required by law to follow. And that's referred to as the pre-adverse letter and the adverse action letter. Basically, a letter with certain information on it, a copy of the rights, and a copy of the background report has to go to that applicant saying, hey, we did a background on you, which you already know. We found some stuff, and we're reviewing it. This gives the applicant time to look at it and find anything that's wrong. And there could be reasons that it's inaccurate. They could have been the victim of identity theft from somebody who's using their name. Maybe they have a twin brother that has a similar or same name and date of birth. Maybe the court messed up and their records are wrong. So whatever the case might be, this gives that applicant time to come back to you, the employer, and say, hey, this is wrong, in which case they can then approach the vendor, like my firm, and say, hey, this one particular item is wrong. And then we are required to reinvestigate that. There's no charge to you, the client, no charge to the applicant, to verify that one aspect. And then either it's legit or it's not. Then after a period of time, the law doesn't state, but the industry standard is 5 business days. If they haven't come back with a reasonable explanation that you believe in, or they haven't done anything, and my experience is when you send them this letter, they just disappear because they kind of figure, all right, I've been caught, I'll apply somewhere else. You send the second letter. The second letter basically says, we're not hiring you because of what's in this report, thanks. But it's a very important step because employers are getting sued for not following that. So another topic is the Equal Employment Opportunity Commission, which they have jurisdiction over employers with at least 15 employees, and also most labor unions and employment agencies are covered. And there's an aspect of some guidelines that they issued in 2012. I'm not going to go too much into it because I could spend hours on this one topic. It's very confusing and very in-depth. It's guidance but not law, but basically a regulatory agency says, hey, employers, here's how we're going to look at any complaints we receive. So that gets most employers to kind of perk up and say, oh, I guess I should listen to what they have to say. The bottom line is you should not, as an employer, have a policy that anyone who has a criminal record, we are not going to hire. That would be a very bad idea if you have that policy written or otherwise, or practice. Instead, you should look at each individual applicant and their background and look at it individually. Under law, there's something referred to as the green factors, which has to do with the name of the civil case. And that case sort of distilled is, what was the nature and gravity of the offense, the time since the conviction or the completion of the sentence, and the nature of the job. So take those factors, take a look at what the record is, and take a look at the applicant. So something totally not related to their duties 20 years ago probably doesn't have a lot of effect on what they're going to do as your employee. If you're hiring them as a bookkeeper and they were released from prison 6 months ago for embezzlement, which is again stealing from their employer, I would say you have a pretty strong case that says that's directly related to their position and therefore you're clear not to hire them. So again, you have to look at each one individually. So that brings us to Nevada law. That was the overview of federal law, which of course applies. And being the Las Vegas Metro Chamber, I'm going to assume most of you out there are Nevada employers. So we'll take a look at a few things that relate to Nevada. Number one, Nevada is the most heavily regulated when it comes to organizations that conduct background investigations or background checks. Basically, anyone that does backgrounds on an employee here in Nevada or for a Nevada employer must be licensed as a private investigator. Nevada license 901A. Yes, I put that in there in case regulatory agencies are listening to this. We are licensed. Many are not. I would check on that. And the reason I say that is you hope you don't need to pull out this background report at a later date. But it's kind of like insurance. What if something bad happens? You're going to go to your file, you're going to pull this report out and say, look, we did a background. And if the other side says, yeah, they're not licensed, so what they did is a criminal activity in Nevada, that just doesn't look good for you. And some stuff about the law as to why, and I'll skip all the boring stuff. Also, there's a Attorney General of the state of Nevada opinion letter where this was questioned by an organization once, and the Attorney General said, nope, you need a license. And then there's also something called a case law, and this is a district court case decision in Nevada saying, yep, you got to have a license. So we have it covered in statutory law, Attorney General opinion letter, and case law. And we'll skip some of the more boring stuff. So another Nevada law, or Nevada revised statutes, there's a time limit on reporting certain records. So you shall not disclose, and this is again in that background check report, that consumer report, bankruptcies more than 10 years old, civil judgments, criminal non-convictions, arrests, and other adverse information more than 7 years. Now that happens to coincide with federal law, so it's not too much of a problem because under federal law you can't report it either. Employment credit reports. So in 2013 they passed a law that basically says you as the employer cannot run a credit report on an applicant for employment purposes. And there's a whole bunch of legalese that goes into positions and what the ramifications are if you were to do that. However, like a lot of laws, there are exceptions. So, you can use a credit bureau report when required or authorized by state or federal law. So the law says you have to run one, then you got to run one. Upon reasonable belief that the individual is engaged in specific activity, et cetera, that's referred to as internal investigations. So when I ran investigations for Casino on the Strip and we thought somebody was stealing and we started to build a case, if it was involving finances, we could run a credit report and use the information on there if it was applicable. Number 3 there, when information in the credit report is reasonably related to the position for which the employee or prospective employee is being considered. Well, that makes sense, which is kind of surprising because it's in law and it makes sense. So what's reasonably related? So care, custody, handling, or responsibility for money, financial accounts, corporate credit or debit cards or assets, access to trade secrets or other proprietary confidential information, managerial or supervisory responsibility, and then also for law enforcement officers. So if the job position relates to one of those things, handling personal information of others, accessing personal financial information of others, employing a financial institution, and no surprise in Nevada, employment with a licensed gaming establishment. That's kind of a given. So if any of those apply to you as an employer, then you can run a credit report. Next one, most people never heard of this one, but it's there. 179B.270 of the Nevada Revised Statutes. So the Department of Public Safety runs a sexual offender database. State law says you cannot use information from that database for an employment decision, which kind of shocks a lot of people. So I own a business and I have children as clients, and so I want to check that for sexual offenders because I don't want to hire them, because that all makes sense, but I can't use that database. I'm not going to say there are ways around that, but the law says you can't use that database. It didn't say you can't use other databases, so we do find other ways to check, but you cannot put in a report somewhere, hey, I checked the state DPS sexual offender database, the person was on there, so I didn't hire him, because you're violating state law, and you don't want to do that. Another one that's not exactly background check, but kind of related, and related to all employers in Nevada. Nevada is one of only a couple of states that is very serious about personally identifiable information. So a name and a social security number, driver's license, identification card number, account number, credit card number, debit card number, et cetera, personal financial accounts, so on and so forth. These are all PII, or personally identifiable information. So sending PII via regular email through an e-fax system, not a regular old-fashioned 1950s technology fax machine, not encrypting it when it's stored on your servers or your desktop or your laptop or whatever, that's a problem. You're liable for that. You're liable if that data is compromised, and you can be sued for it. Another one, unlawful acts of employer relating to social media accounts. So some places, it's been known that hiring managers, interviewers, whatever, realize that when they go check your social media accounts, let's say Facebook, depending on how you have it set up for security purposes, an outsider, not a friended person or you, sees a little bit different information. So they would say, all right, what's your login credentials? What's your username? What's your password? Then they log into it as you, and they can see everything. And they figure they're going to see you, I don't know, smoking a bong or doing something violent or something that says, oh, I'm not going to hire this person. Well, in Nevada, it's illegal to ask for that information. You cannot ask them for that login information. So that's the basics. Again, this is not meant to say, here's everything you ever need to know about backgrounds, but really more of a, here's some laws that are out there. You can't get around the laws. You can't say, oh, I didn't know. That's just not gonna work for you. But obviously, if you got any questions, let me know. My contact information on there. Feel free to email, call, whatever. Be happy to help you out. Or if I see you at the next chamber meeting, feel free to walk up and say, hey, I got a question on whatever might be related to backgrounds.
Great. Again, if you want to ask a question, you're more than welcome to. You can type it into the chat box on the bottom left corner of the screen. And if you're just tuning in on your phone, you can press *7 on your phone to unmute your line. And we'll wait a minute or so to see if anyone has any questions. Questions here at all? No? No?
I answered everybody's questions.
Well, again, if you would like to ask William another question outside of this webinar, please feel free to. His information is up on the screen right now. Thank you so much for
Glad to be here.
this webinar today. Just a quick reminder, everyone, please join us again next week for another Chamber University. We're going to be talking cybersecurity for your business, another really huge, important topic. So thank you again, and we'll see you all next week.